Hello and welcome back to another episode of the Injury Law Pod. I am your host, Eric Bartlett, 28-year personal injury lawyer, and this is the podcast where we talk about all things personal injury law related. On today's episode, we're going to delve into the world of workers' compensation. And the question on the table is, if you have a heart attack while on the job, or if you develop a hernia while on the job, are those injuries, conditions that you can make a claim for under the workers' compensation system? And today we're going to break down a couple of things. We're going to talk about Missouri law and Kansas law and how the two states' workers' compensation systems handle those particular claims, and exactly what it looks like if a person experiences one of those two injuries or conditions again at work, and how hard is it to make those claims. That's what we're going to take a look at today. So I guess most everybody probably understands that a heart attack is where there's some usually a clogging of an artery, something like that, which creates a blockage in the heart, which then stops blood flow, and that leads to a damage to the heart muscle. And obviously, heart attacks are very serious situations and can lead to both long-term problems and or even death. And so obviously very, very serious medical condition if it occurs. And on the other hand, hernias, again, I assume most people understand hernia is a situation where there is a tearing or a perforation of the muscle in the groin area, which then allows a protrusion of the intestine through that muscle tear. And obviously, it can be very painful. It can be an emergent situation. Usually, it's more of a situation that needs to be dealt with surgically, not necessarily emergently. But again, can be a real problem. And, both of these conditions, injuries, are specifically addressed under the law because, unlike, say, breaking a bone or tearing a muscle in your shoulder or injuring your back, herniating a disc, something of that nature, these two particular conditions prove difficult because there can be other factors at play. Both of these can involve pre-existing conditions. So somebody's lifestyle, genetic makeup, whatever that is, can be leading them down the road to a heart attack. And so the question becomes, is the heart attack something that just coincidentally happened while a person was on the clock working? Or was there something about the work that caused the heart attack to happen? That's what led up to the heart attack. And the same kind of goes with a hernia. A hernia can be developing in a person. And again, it can be very unclear whether the hernia was specifically something coming out of a person's employment, or it was something that was existing, and now the hernia is there and somebody believes it's because of the work they do, and it's trying to make that connection that proves very difficult. And so again, Missouri and Kansas have both taken a look at these particular conditions and tried to address them in the work comp world, setting forth some standards. If a person's going to claim one of those, what are they going to have to go through? What are they going to have to prove to put that together to get covered as a comp claim? And so what we know is that occupational diseases, including heart-related conditions, are generally considered an underreported situation in workers' compensation claims. And probably the reason for that is because of the difficulty of making the connection. Somebody has a heart attack, and again, if it happens while they're working, they may not necessarily think, well, this is because of the work I was doing. It's just a heart attack that happened based on lifestyle, based on genetics. And the same thing goes with the hernias. Again, it's a difficult situation. People may lead an active lifestyle outside of work. And when a hernia arises, they don't automatically think, oh, this is related to the work I do. And so I think both of these conditions are generally considered underreported conditions as far as workers' compensation goes. However, in my own personal experience, we have represented people on both. Again, they're very difficult. So we have to turn down a lot of people that call about heart attacks for sure. Hernias, we are more likely to jump in depending on what the framework is surrounding the hernia. Usually if the employer has the employer slash workers' compensation insurance company, if they've already been covering it, they're not denying it. If they've provided surgery to repair the hernia, we're usually happy to jump in and help get a permanent partial disability settlement at the end for a client. With heart attacks, again, we've reviewed quite a few of those. It usually involves getting medical records, hearing from the person that's reaching out to us about what exactly their work entails. Are they under unusual stress and strain from their job more so than they are in the outside world? Again, what's their lifestyle look like, right? What is their medical history? Do they have a family history of heart related conditions? So there's a lot that goes into trying to figure out how we can help somebody with these types of conditions when those things just happen to have happened while they're on the clock at work. And so in Missouri, essentially for a heart attack to be compensable in a work-related activity, that work-related activity must be the prevailing factor. That's the legal phrase. Must be the prevailing factor causing the condition. And whatever happens, the same reporting requirements are in place where an employee has to report the condition to the employer within 30 days of it happening. So if somebody has a heart attack and they go out and they're getting treated and whatever, and if they don't report it to their employer as a possible work-related condition, they could be forever barred from trying to get it covered as a work comp claim. So in Missouri, that's a 30-day reporting requirement, which is the reporting requirement for all work-related injuries in Missouri. In Kansas law stipulates that compensation for heart-related conditions requires evidence that the exertion at work was more than the employee's usual work in the course of regular employment. So there's this heightened standard. And in Kansas, you have 20 days to report an injury. So you have a shortened time frame. So if someone has a heart attack, and again, the clock is running for them to report it to their employer as a potential work comp claim. And so again, in both states, if for any reason somebody thinks that their heart attack is coming about because of the work and the stress or whatever it is that they're doing, they need to make sure they report it to their employer so that it's properly preserved as a work comp claim. Now, once a work report is made regarding a heart attack, medical records are going to become very important. And as I just kind of previously indicated, you're going to have to go back and you're going to have to see what the person's medical condition was before this heart attack actually hit them. And, if it's somebody that has not had any history of heart conditions, and then all of a sudden they have a heart attack while they're at work, well, obviously that is a step in the right direction of getting this covered as a potential work comp claim, because now you don't have some history out there of heart related issues that is going to override whatever may be going on at work. So again, if you've got somebody with a history of heart related complaints, medical workup, things like that, it's going to be harder if they actually have a heart attack on the job to make that a work comp claim. And again, medical records are always going to be important, and even the after treatment and what is said in the records about their work conditions, anything of that nature. Lawyers and insurance companies are going to be looking at those documents to see what kind of picture there is to connect this to the employee's work. Most of the time, employees that are claiming a heart attack as a result of their work are going to run into an insurance company arguing that the injury or the condition stems from existing health issues rather than work-related activities. And so again, a review of medical records, prior medical records, is absolutely going to happen if someone is claiming a heart attack was caused by their work. So if we look at Missouri, Missouri has a statute, a law on the books that specifically deals with heart attacks and work-related claims. And basically, here's what the law says. A cardiovascular accident, a heart attack, or myocardial infarction, heart attack, suffered by a worker is considered an injury only if the accident is the prevailing factor in causing the resulting medical condition. And I've mentioned this prevailing factor earlier. So what does that mean? That means that the work-related accident or exertion must be the primary factor compared to all other contributing factors in causing the heart attack. So again, and this is kind of important because, it might be discovered, right, that somebody had a blockage or, had a narrowing of the arteries or something of that nature prior to the actual heart attack occurring at work. But what has to be shown is the nature of the work is such that it was the primary factor compared to all other contributing factors of this heart attack occurring. And so, you're going to have to look at simply experiencing stress at work or having a pre-existing heart condition that is triggered while on the job does not automatically make a heart attack compensable. Instead, there must be clear medical evidence that the job duties were the main cause of the heart attack. So what's a great example? Well, if you have somebody, let's say you have a road worker, highway transportation worker who works outside in the heat, shovels asphalt, works 10-hour days, and they suffer a heart attack on the job. Well, that one is probably going to be on the spectrum of more likely to be a compensable work comp claim as opposed to the office worker who works at a desk and, handles things in the air conditioning, all of that. Now, Where the office worker might have a different experience is if for some reason their job produces a great amount of stress on them. They're under major deadlines. They have a lot of projects that they're handling, things like that, stress that is above and beyond the normal stress of any job. Okay, that might be something that would change that scenario. But you can just kind of see on that spectrum, right, what we might be looking at as a more likely compensable claim as to a more complicated effort at making a compensable claim. Now, prior case law in Missouri suggests that a heart attack is generally not considered an accident for work comp purposes unless it results from unusual exertion and strain. And again, that's kind of what lawmakers put into place when they put a law on the books detailing that. Again, in any of these kind of claims, medical evidence is going to be critical. And if we as lawyers get the medical records and we think there's enough there, we're going to need a medical professional to take a look at the medical records and possibly examine the client and put this together with a medical opinion that their job related exertion was the primary cause of the heart attack. If the heart attack occurred while performing normal job duties without any extraordinary physical exertion, then it might not qualify. So again, in my example earlier of the road worker, again, let's just say they're out, it's a normal day, temperature isn't out of control, right? They work an 8-hour day. This is something they do all the time, whatever. Then that might not meet the requirements for putting the heart attack together under workers' compensation. But the burden of proof is on the employee, or if that heart attack led to the death of the employee, then the surviving dependents, but they're the ones that are going to have to prove that work was the prevailing factor. So it's very difficult. Okay, turning to Kansas and Kansas law, they too have a special statute dealing with heart attacks. And essentially, the Kansas statute reads that compensation for coronary or coronary artery disease is disallowed unless it's demonstrated that the exertion leading to the injury exceeded the employee's usual work duties. And this means that for a heart attack to be compensable, the work-related exertion must be more strenuous than the employee's routine task. So you can see both states address it in pretty similar fashion. They just have different standards, at least in name, that they operate under. Now, it's also interesting to note that for firefighters and law enforcement officers in Kansas, there are specific provisions, and basically for events occurring on or after July 1 of 2014, coronary or coronary artery disease or cerebrovascular injury, stroke, is compensable if, number one, the injury can be identified as caused by a specific event occurring in the course and scope of employment. Two, the coronary or cerebrovascular injury is the prevailing factor in causing the disability or impairment. And three, the physical activity or strain involved was not usual for the employee in the course of their regular employment. So what is all that? What's the takeaway from that? As a police officer or a firefighter, it's really hard to make a work comp claim if you have a heart attack or a stroke on the job. And basically, the lawmakers have put it out there that, firefighters out fighting a fire, they have a heart attack, it's going to be an uphill battle to get that covered. But these provisions, which are often referred to as the Hart Amendment, they set a higher threshold for compensability of heart-related conditions, requiring clear evidence that the work-related exertion was beyond normal duties and directly caused by the medical event. Given the complexities of such claims, it's advisable, of course, if you think that a heart attack or a stroke or something like that is related to your work, reach out to a lawyer and, see what the thoughts are, see if they're willing to get your medical records, take a look, see if they're willing to get your medical records and see if they think there's enough there for clear evidence to connect those incidents with your work. Let's turn for a minute to hernias. And again, heart attacks and hernias, even though completely different injury conditions, they both share this heightened standard of proof in the Missouri work comp system or the Kansas work comp system. And again, the reason for that is because, as I said at the top of the episode, these are things that just are not clear cut. It's not like somebody, now I'm not saying always, right? Sometimes somebody goes to lift something and they immediately feel pain in their groin and they're diagnosed with a hernia. And that's obviously a much better situation than, reporting to your employer that based on doing the same type of work and lifting for a certain amount of time, now you think you have a hernia and, meanwhile, outside of work, you're a weight lifter, you're very active, and now causation wise, it's just not clear like what led to the hernia. So, but that's why these heightened standards are in place. And so both Missouri and Kansas, when it comes to hernias, they also have laws on the books that deal specifically with hernias and workers' compensation. So in Missouri, you've got a few things that have to be met if you're trying to connect a hernia to workers' compensation. Again, the hernia must be clearly recent in origin and result from a specific work-related incident. So again, if you come in telling your employer that, you've been experiencing pain in your groin for some time now, you do the same type of work, whatever it is, that's probably going to be denied. If you experience some immediate pain from doing something and you go to a doctor, they diagnose a hernia, that's more likely to be covered under workers' compensation. Now, again, the hernia, the second element under Missouri law is that the hernia must have been caused by an accident arising out of and in the course of employment. And again, same idea, right? You've got to be working at the time something happens that causes the hernia. And again, same reporting requirements. You've got to make sure that it was reported right after it happened. You've got 30 days. The sooner, the better. Again, for causation purposes, the more time that goes by, again, there's going to be more questions about, well, what are you doing in your off time? Things like that. And then finally, there must be evidence of the hernia protrusion observed by a doctor. So when they examine your groin area, there has to be a noticeable protrusion, again, through that muscle tear in order for the hernia to be compensable. And these requirements are designed to ensure that the hernia is directly related to workplace activities and it's promptly addressed. It's important to note that if a hernia results from a pre-existing condition or is not immediately reported, it may not be covered under work comp law in Missouri. So in Kansas, for a hernia to be compensable under their workers' compensation law, it must be a traumatic hernia directly resulting from a specific work-related injury. And traumatic meaning, right, somebody was lifting something, pulling something, whatever it was, and it happened like that, not something that developed over time. The law requires that the hernia arises out of and in the course of employment. And additionally, if the hernia is operable and the employee unreasonably refuses to undergo the recommended surgical repair, they may forfeit their right to benefits under the Workers' Compensation Act. So if you're going to report the hernia, you're going to claim the hernia, and a doctor says you need to have it surgically repaired. If you don't want it surgically repaired, then it's probably going to go nowhere quickly in the comp system under Kansas. It's important to note that the compensation for a traumatic hernia is limited to temporary total disability, which basically means while you're off work from the hernia, you can get weekly benefits. But that's basically it. And that's up to about 12 weeks. So that's the extent of a Kansas work comp hernia claim and the benefits that flow with it, including the medical. Whereas in Missouri, you actually can get a permanent partial disability settlement from a hernia. So again, same as Missouri, very important. Report these things immediately to an employer. If something has happened while you're working and you're experiencing pain and you think you might have just had a hernia develop, because the more time that you let pass, the more difficult any of this is going to be. Other things to keep in mind is you're going to, if there's a history of having hernias, that's probably going to make things harder. In Missouri, for example, if the worker already had a hernia, it must be proven that the new hernia is separate or was significantly worsened by the work injury. It's going to get really hard if there's any history of hernia on the employee that's now claiming a hernia from work. A couple other interesting notes. If it's a hernia in the groin and that occurs, surgery is typically required for workers' compensation benefits to continue beyond the initial medical expenses, just like in Kansas. So what are the typical reasons that we see insurance companies denying hernia claims? Typically, that there was no specific accident or unusual strain at work, that the injury wasn't reported within 30 days, or that medical evidence doesn't support the claim. So that's why all of these things are really important to keep in mind. If you believe you had a traumatic hernia at work, you need to make sure you're taking the steps to preserve the claim and, make sure that causation is as clean as it can be between the hernia and the work incident. So other resources, we'll put some resources in the notes, but the Missouri Department of Labor has information on hernias and heart attacks, and also the Kansas Department of Labor does as well. We'll make sure we post those. And again, if for some reason you think you've had a heart attack or a hernia and you think it's caused by your work, you're always welcome to reach out. We're happy to take a look at the situation. And if we can help, we certainly will. So until next time, I hope you found this episode informational and helpful. And I hope that you stay safe and well.